Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. It's my pleasure to review a book which I found fascinating because it's an area of law I practice in, been involved in it for a long time now. It's called Debt Restructuring. It's the second edition of a work from OUP, Oxford University Press. It's this book here. Now, I'm going to read the names of the people. Now, I may get the actual pronunciations wrong, so I do apologise. But these are the editors and authors: Rodrigo Olivares-Caminal, John Douglas, Randall Guynn, Alan Kornberg, Sarah Paterson and Dalvinder Singh. My apologies if I have not pronounced your names correctly, but what you have produced here for us is a very good book indeed, and it's one that's very important because I and other people have been looking and calling now for a long time for a complete review of the way we deal with insolvency. Now, I've given the title, Elizabeth, I've talked about this book, and I've given the title for this book, Fundamental Reading for Everyone Touched by the Issues of Insolvency, published at a time when change is urgently needed in this area of law. So I get my commercial in, and I'm going to mention a bit more, which is not in the written review in the journals and on the web, but it's what Philip Wood has said in his comments. But before I do that, let me show you the book first of all, because there it is, this green cover. It's a heavy book. Then we go hardback. There's the spine, and then there's the back. There's nothing on the back. Now, the book runs to quite a large number of pages. Nearly 800 pages in total, and it is paragraph numbering, not page numbering. So if you're looking for things, it's the paragraph numbering. Now, it's a big index. There in fact are, it's a big index. There are a large number of areas covered. Then you've got the annexes at the back. In fact, one major annex, which is the key differences between US bankruptcy and US bank resolution. So it's quite important. You can see right at the back the paragraph numbering. We'll just go back a little bit. Again, you can see paragraph numbering used throughout. This is chapter 12. And you've got some footnoting to justify assertions made. Now, at the front, you've got an excellent debt restructuring front cover, then a foreword. And I'm going to just mention the foreword. The foreword's been written by Philip Wood, who will be known to many of you. He's head of Allen & Overy's Global Law Intelligence Unit. He wrote this, he's a professor. He wrote this on the 8th of July 2016. And he makes some points. He says, for instance, one would expect that the recent rapid developments in insolvency laws would exhibit a common philosophy. This is not so. The attitudes of the mosaic of jurisdictions point in all directions of the compass as legislators wave a legal wand in the hope of, by magic, conjuring up assets out of thin air. Now, I haven't put that in the review, but that is absolutely the case, because you can't get blood out of a stone. I wish a lot of people would realise that. Obviously, again, he goes into a lot more detail. He says the strict black letter rules of bankruptcy law are the backdrop against which the resolution of financial disputes is negotiated. It's probably true that by far the majority of financial problems are resolved by a private restructuring with or without a final judicial stamp. Now, that has been, I believe, the policy for some successive governments for some years. But it is my view that the insolvency rules, certainly in the United Kingdom, should be reviewed urgently, because I do think that we've got to look afresh in this century at the way that we deal with these problems. He calls the book a major contribution to the practice and the law of this fundamentally important topic. He's absolutely right. He always has been. He's an excellent man. I have met him, and I'm delighted to give him a little bit of an ad about what he said. Then you've got the preface, which is the introduction to the book by the it talks about corporate restructuring, bank recovery and resolution by Professor Rodrigo Olivares-Caminal. There we go, sovereign debt restructuring, about the book. Do read that, because it tells you what the book is really about. Then after that we get into the contents section. You can see the structuring there. Just going through, there's quite a lot. I'm not going to spend a lot of time on the various parts. There are in fact three main parts, and you see the names of the people who have contributed listed in the contents section. Then there are biographies of the authors, who are very, very experienced people. This is a wonderful book. Tables of cases, running all the way through there alphabetically. Legislation, of course, as well, European Union legislation to start with, then UK legislation there, and so on. There's a lot of that. Then there's this very useful list of abbreviations. Very important in this day and age, because it's quite possible that you may not remember what an abbreviation stands for. I certainly have problems sometimes, and it's useful just to flick back and have a look. Then you get to the parts. Part 1 starts off with corporate debt restructuring. Very useful here. You have a mini index for each chapter, so you should be able to find things very easily. That's done on the basis of the paragraph numbering again, rather than the pages. And then you've got subheads, and then you've got the paragraph numbering at the side there, and then you've got the footnoting as well. And you can see it runs through directors' duties to promote a restructuring in the US and so on. Now I'm going to mention a couple of cases as well in this book. I thought this was a very important book internationally. It's a book that's relevant to us, of course, in the United Kingdom because of what we've been going through, the turmoil of 2016 with the referendum, Brexit and the aftermath, and I'm recording this in the autumn. But what do we say? So we say this, because I'm going to look at it from a practitioner's point of view, as an insolvency practitioner, as a barrister, as counsel in the lower courts, dealing with quite often with quite low sums of money, not the very big sums of money. But I see the same problems, and Philip Wood has identified some of them very clearly in my view. But for many then, insolvency law requires substantial and overdue review for both practitioners and all involved in such proceedings, because they agree that global pressures make the need for change urgent, because we do have to look at this afresh because of some of the problems that have emerged. The Oxford University, we think, have to be congratulated because they've stepped up to the plate again to produce this new second edition of Debt Restructuring. And the new second edition, which has been written by these excellent, very eminent, experienced people, gives us a detailed legal analysis of the international corporate, banking and sovereign debt restructuring from the perspective of both creditors and debtors. So the book has, in our view, quite a wide reach, and rightly so, because one of the important things is to remember all the parties involved in these proceedings and make sure that there is some form of equitability, equity in the way in which they are dispatched, because one of the criticisms, certainly in the lower courts in Britain, in England and Wales, is that sometimes the relationship between the two parties, the creditor and the debtor, can be very uneven, and sometimes it's a concern about the judicial orders that can be made. So that is a point which I think is worth bearing in mind, whatever real level you're at, frankly. What the authors have done here, though, is they've set out practical guidance to assist practitioners, policymakers, researchers and academics to understand current developments in debt restructuring, and it provides solutions for creditors holding distressed debt and debtor options in a distressed scenario, to use their words. It should be compulsory reading, we think, for public servants and members of the judiciary too. And what I would add there is that I think probably it's something that the civil service should be involved in, because the question here is, who is actually in government responsible? Now, it could be business, it could be the Treasury, it could be the legal people. Ministry of Justice are not interested, Treasury probably not interested, so it's probably the business department who are the people you have to go to. But there's been an awful lot of shifting of who's responsible for what, and actually the bottom line in my view is it's actually the Treasury, because they have a unit there which looks at it. But I'm not going to say any more about that, because that's probably a little bit outside the scope of this book. But it does get to the basic point which Wood makes and I make, and that is that this is something that should be done without judicial interference, where if at all possible. That has been the policy, I think, of successive governments for the last 20 years or so, and I think that should remain. Because if you start interfering in the legal world with this, it's never any good for business in the first place. And that's always been a basic principle in terms of company law or corporate governance. At least that's my interpretation of it. So where do we go from here? We found that the corporate debt section of the book is a highlight, because most useful because it's included some very significant changes, such as our Supreme Court's ruling in the Uracell case and the disapproval of the point of no return test for balance sheet insolvency, or the endorsement of the well-known Cheney finance decision on cash flow. Now again, we've got some useful cases coming in. They are mentioned. They will be known. I'm being a little technical here, but they will be known to you if you're a practitioner. In addition, changes in the treatment of schemes of arrangement since the finding in the Rodenstock case are covered together with the recast European Insolvency Regulations, the EIR, and a further Supreme Court decision which was made in the case of Rubin. So again, you see there's quite a lot of case law coming into this. And as I say, I don't quite know where we're going to be going in the next few years because of what has happened with the referendum. The book is, of course, global in chapter, so there's a lot of American stuff. The United States of America obviously is featured very heavily, includes limitations on the bankruptcy court jurisdiction from the authorities of Stern and Marshall. And it also reviews the Radlax decision, covering the rights of secure creditors to credit bid in a sale of their collateral under a Chapter 11 plan. Again, I'm being very technical here, but that's information which is new for this book. Other significant case law issues include consideration of the various safe harbours provisions of the Bankruptcy Code relating to derivative and other financial instruments and cases concerning the effect of a foreign court order in the United States. And again, we're very much trespassing on international law here in that sense. But of course, everything is global today. And frankly, the legal systems of the world are going to have to recognise, I think, this in a much greater way than they have done so far. That's for the future decade, probably. In the meantime, in the bank resolution section of the book, the UK part also has been substantially amended to reflect the new system of macro and micro prudential oversight with the establishment of the PRA, the FCA, the FPC and the FSCS. See, you've got all these abbreviations, so have a look in there if you want to know what they are. The authors have reflected changes introduced by the Financial Services Act 2012 and by the Financial Services Banking Reform Act 2013 under the coalition government. They include a new chapter in this part on the EU framework on the resolution of banks and financial institutions, which analyses and explains initiatives such as SRM and the Bank Recovery and Resolution Directive. And I think that will be of help to quite a large number of people involved in those fields. Of great interest to the international practitioner, of course, is the US chapter, which reflects changes in Fannie and Freddie conservatorships, I'll get that right, including the FDIC's SPE strategy under Dodd-Frank and the proposed GLAC requirements and the resolution plan filings. Again, very technical, but again useful, I think, for people dealing with the US jurisdiction who are probably also perhaps based here at the moment in London. Now, in the sovereign debt section, there is detailed coverage of the New York litigation on the pari passu litigation and its interpretation in sovereign debt contracts. And in fact, sovereign debt, of course, being one of the major three themes of the book. Also, this section of the book analyses the adoption of the single limb tax in the aftermath of the Greek restructuring, as well as the proposal for creditor engagement clauses. So you've got a wealth of detail throughout of an international variety, which I think will be of help to everybody. The book also provides what it calls, and I'll quote here, the full analysis of the EU architecture implemented to prevent a sovereign debt crisis. Well, that's interesting, including the creation of a new stabilisation mechanisms, the EFSF and the ESM, and the challenges presented to the single currency area. Although it's quite possible that a new third edition will appear early because of Brexit. Now, as readers can see from this review, the detail is heavy throughout, as to be expected from an from an OUP house style. It fits in very much with the house style, and they've built on the first edition by including a lot more detail, and I've highlighted the changes, I hope, in this review which people will find helpful. The publication date, of course, is cited at 2016, and I'm recording this in the autumn. Here's the book again. It's a heavy book, nice green cover, pea green, there we go. There's the spine, nothing on the back. Just opening it in the middle. This is competition and valuation, banks in distress. An important subject at the moment because bankers get a very bad press. Some of it is deserved, some of it isn't, I hasten to add. We've got here Chapter 8, Resolution of US Banks and Other Financial Institutions, because we all remember some of what I will only describe as scandals that have taken place in the past. And I think this book is trying to give you a little bit of history, apart from anything else, as to what's happened and where we actually are at the moment with debt restructuring. As I say, it's very much in the Oxford University Press house style. I think the authors are to be congratulated for bringing together the subject and actually making it reasonably readable, because it's not the easiest subject to understand, frankly. But thank you anyway to everybody concerned. Do look at our review on the web and in the journals, and in the meantime it's well worth having a look at. And don't forget the abbreviations, because I've been having problems with them myself. Thank you all. Bye bye.